in the Circuit Court of the 20th Judicial Circuit, in and for Charlotte County, Florida. Felony Division, State of Florida. vs. Tauna Bogle. Defendant case hashtag 17-956 CF. I. Defendant's notice of intent to rely on Williams Rule evidence. Comes now the defendant, Tauna Bogle, by and through undersigned counsel. Mark C. DeSisto, ESQ, and hereby gives notice, 10 days or more prior to trial, of its intention to introduce testimony pursuant to Florida Evidence Code 90.402, 90.403, 90.404 and 90.405, 2. Facts. 1. The defendant is charged with solicitation of perjury in an official proceeding FS 837.02, 1, 777.04, 777.011, a third-degree felony. 2. A tenured confidential informant, hereinafter CI, of the Charlotte County Sheriff Office, hereinafter CCSO, made allegations that were the catalyst which resulted in the stated charge, supra. 3. The CI is Jamie Omar Sepulveda. He is currently referred to and identified in CCSO records with his informant control number of CI 15-57, also as designated in the PCA in this matter. 4. While Jamie Omar Sepulveda has been utilized on and off for years as a CI by the CCSO, in this matter he came forward without initial prompting by the CCSO. Page 1 of 6. 5. Nonetheless, subsequent to the allegations being made by the CL, the CCS used him in his CL capacity to continue the instant investigation. 6. The CCSO Operational Manual, General Order 13.11 Confidential Informants. Effective date, March 31, 2005, reviewed date, September 2016, illustrates the proper requirements, and the proper handling and procedures relevant to the use of confidential informants by the CCSO. 7. The Operational Manual, in part, states the following regarding the use of a CL by the CCSO. Seconds Calia 42.2.7, 1. Members' responsibilities. A2. Prior to utilizing the informant, a check will be made to determine if the informant is currently under indictment, or out on bond, wanted for any criminal offense, on parole, or probation. 3. B. Members will not utilize an informant if it is known that he/she is wanted for a criminal offense. Arrangements should be made to surrender the informant. He/she may be utilized after bond requirements are met. 8. During instant defense counsel's ongoing investigation, it appears there are active and open warrants dating back to 2005 from Harnett County, North Carolina. Regarding the instant CL, the warrants were returned unserved on December 3, 2005 by the Coates Police Department. 9. In the 05CR052483 warrant for arrest, issued April 11, 2005, Jamie Omar Sepulveda. The CL in the instant matter, is wanted for the following alleged violations of the law. From the state of North Carolina. Sale and delivery of a controlled substance to a minor, it is alleged the CL, by delivering a controlled substance, marijuana, which is included in Schedule 6 of the North Carolina Controlled Substances Act, to TAM, a person under 16 years old, but more than 13 years old, namely 15 years. The defendant was at least 18 years old or older at the time of the offense. False imprisonment, it is alleged the CL intentionally did detain T.A.M without her consent. Page 2 of 6. Contributing to the delinquency of a minor, it is alleged the CI, unlawfully, willfully and knowingly, while at least 16 years of age, caused, encourage and aid T.A.M, age 15 years, a juvenile to commit an act, using a controlled substance, whereby that juvenile could be adjudicated delinquent. Attached herein Exhibit A. 2 pages. 10 in the 05 CR 052595 warrant for arrest, issued 4117/2005, Jamie Omar Sepulveda. The CI in the instant matter, is wanted for the following alleged violations of the law. From the state of North Carolina. Breaking or entering, it is alleged the CI, did wrongfully break and enter a building. Of Carla Parish, Southsea. Assault, it is alleged the CI did assault and strike Carla Parish, Southsea, a female person by hitting several times. The CI was at least 18 years of age when the assault occurred. Attached herein Exhibit B, 2 pages. 11 Via communication with the Coates Police Department, there is another outstanding warrant, 05 CR 052596, also for the arrest pending for the instant CL. The information provided stated the charge is for impersonating a police officer. FE Coates PD was unable to locate the warrant at that time. Nonetheless, this is currently being followed up on evidence of other bad acts, which are collateral to the crime charged and not admissible. Under Williams' rule, which allows admission of prior bad acts, is admissible if relevant and not more prejudicial than probative. FSA 90.403. Evidence of other crimes, wrongs, or acts is admissible if 1. It is relevant and has probative value in proof of the instant case and some material fact or facts are in issue. 2. Its sole purpose is not to show that bad character of the accused. 3. Its sole purpose is not to show the propensity of the accused to commit the instant crime charged, and 4. Its admission is not precluded by some other specific exception to the rule of exclusion. FSA 90.404, 2. As a predicate to impeachment of witness by prior convictions, 2 questions may be asked: have you ever been convicted of a felony, and have you ever been convicted of a crime involving dishonesty or false statement, and it may be appropriate for the trial court on page 3 of 6. Request of either counsel to instruct the witness out of the presence of the jury as to the types of crime which involve dishonesty or false statements. FSA 90.610, 1. Application. The CI in this matter is a tenured informant for the CCSO. He has been utilized on countless drug cases in the past. He was recently incarcerated in the Charlotte County Jail facing charges punishable by life. Based on the allegations he brought forward in this matter, he received a credit time served plea deal and was immediately released from the jail. He is not the accused in the instant matter. The warrants have never been served supra. The CI has been utilized as an informant and also has been released from incarceration by the Charlotte County Jail while the warrants remain active and unserved. The CI has been handled through the regulated CI program, which procedure is set forth in the operations manual of the CCSO, supra. The requirements and controlling procedures used regarding this informant were not in accord with CCSO policy and orders. It appears the CCSO was not informed of these outstanding warrants by the CL, or if they were, was not investigated or ignored completely. It appears the CCSO violated its own rules and regulations in countless incidents during the utilization of the CI. As of this date, even with providing this information regarding the warrants to local authorities in this matter, there has been no information provided nor addressing this issue with defendant. There has been no explanation, if any, to apprise the defendant as to the accuracy of this information, nor has any active attempt known to the defendant taken place to arrest the instant CI. Unless the information provided by the Coates Police Department is inaccurate, or if the warrants address another individual named Jamie Omar Sepulveda, that is not the CI in the instant matter, then this is a wanted felon, who is alleged to be a danger to minor children, is being allowed to continue to roam the streets of Charlotte County, Florida, undaunted and unrestricted in any respect. Page 4 of 6. Material facts that are collateral in the instant matter will address whether the CI is credible, whether the CCSO followed appropriate procedure, whether a proper investigation was conducted prior to the arrest of the defendant, etc. The answers to these issues and in part affirmative defenses, is para materia evidence the defendant intends to produce during trial. Although the prior bad acts of this witness are collateral and may demonstrate his bad character, that is not the sole purpose of introducing this information. He is not the defendant in this matter, this is purely reverse Williams rule evidence intended to be presented to a jury in this matter. The Florida Evidence Code allows this honorable court to provide the jury with a limiting instruction in these type circumstance, which defendant will be providing to this honorable court at the appropriate time. Failure to allow the defendant of submitting this information into evidence at jury trial, if accurate, would be a denial of due process in affording the anticipated complete defense that will be relied upon by the defendant. Wherefore, the defendant respectfully requests this honorable court to grant this notice of intent by allowing the defendant to present the prior bad acts, reverse Williams rule evidence, of the CI instigator witness, in defense of the alleged charge in the instant matter, if during the discovery process, all same information is found to be accurate. Page 5 of 6. Certificate of Service. I hereby F.Fi that a true copy of the foregoing has been sent by electronic transmission this, I.F. day of 6, 2016, to Office of the State Attorney, 350 E. Marion Ave, 2 floor, Punta Gorda, Florida, 33950. C, : Mark C. DeSisto, Esquire. Florida Bar #, 049-9862. 265 East Marion Avenue Suite 112. Punta Gorda, Florida, 33950. 941-479-6185 fax, 941-575-6400. Primary email, LEOAFFIRS@aol.com. Secondary email, mdes267@aol.com. Attorney for defendant. Co-counsel, Kevin Shirley, ESQ. Felony Division. State of Florida. vs. Tauna Bogle. Defendant case # 17-956 CF. I. Motion to compel further discovery. Comes now the defendant, by and through undersigned counsel and pursuant to Rule 3.220, Florida Rules of Criminal Procedure, and moves this honorable court to order the below listed discovery. 1. Report of fingerprint analysis conducted on handwritten note, hereinafter. Kite, alleged to have been written by inmate Benjamin Porter, defendant's client at time of her arrest, and allegedly sent to CI-15 to 57, Jamie Omar Sepulveda. In the instant matter. This kite is designated as pages 157 to 158 of the discovery package in the instant matter. Herein attached X. A. 2 pages. Facts. 1. On April 25, 2017, the CCSO received a phone call from Jamie Omar Sepulveda, CI-15 to 57, and advised he had contact with the instant defendant without his prompting or request. 2. Jamie Omar Sepulveda, CI-15 to 57, stated the defendant requested he commit a crime by perjuring himself in trial for the defendant's then client, Benjamin Porter. Attached to this claim, was an alleged attempt by defendant to bribe him. in the amount of $2,500, bribery has not been charged in the instant matter, for this alleged solicited false testimony. Page 1 of 11. 3. During the course of the CCSO investigation, Jamie Omar Sepulveda, CI-15 to 57, states he received a kite from Benjamin Porter relaying information regarding the upcoming jail visit by his attorney, who is the instant defendant in this matter. The kite also contains cryptic comments suggesting a bribe is offered for the CL's solicited false testimony. 4. Ostensibly, the CI states the monies in the amount of $2,500 would be paid by the parents of the defendant. 5. During the ongoing CCSO investigation, Detective Wedgwood took taped interview statements of Benjamin Porter's parents separately. He inquired into the ostensible payment from them of a bribe to the CL, the kite allegedly written by Benjamin Porter, and any possible wrongdoing on the part of the instant defendant that they may be aware. 6. Both parents cooperated in these separate unannounced statements/interviews taken by the CCSO, Detective Wedgwood, under penalty of perjury. 7. The replies consisted of no knowledge of any bribe sought or conveyed to the CL. No knowledge of them ostensibly to be the purveyors of the bribe to the CL, no knowledge of the kite allegedly written by Benjamin Porter and conveyed to the CL, and no other information that would support any crime to their knowledge associated with this matter or this defendant. There is no reason to distinguish the replies between the father and mother of Benjamin Porter in their separate interviews/statements, as both statements corroborate each/act and issue that arose in each separate interview taken. Hence, the replies above are the same for each. 8. Mrs. Porter emphatically informed Detective Wedgwood, once being allowed to review the kite, that the writing therein was not the same writing of her son, Benjamin Porter, which she has had the ability to observe and become acquainted with over a period of 45 years. She explained Benjamin Porter only writes in cursive with regard to his signature, and all other writings are done in printing format. Mrs. Porter offered several times during the interview to provide copies of writings of her son/or comparison, which she had available during this unannounced statement/interview being taken. Nonetheless, the investigators showed no interest and did not partake of this offer of crucial evidence. Page 2 of 11. 9. To the contrary, Detective Wedgwood states that he knows Mr. Porter wrote the kite, which would normally be a good reason not to collect the writings offered. Emphasis added, counsels have been unable to determine what evidence supports this finding made by the investigating officer, upon a cursive review of writings completed by Benjamin Porter in court files of the clerk of court. Said writings viewed appear to support the facts as presented by Mrs. Porter, all print. Signature equals cursive. 10. Mrs. Porter asked if CCSO intended to have a handwriting expert look at the kite for a handwriting analysis, at which time it was suggested the kite would be looked at in the course of the investigation, although the investigator once again explained he knew Benjamin Porter wrote the kite without reservation. 11. Jamie Omar Sepulveda, CI-15 to 57 states in his interview that he never sent for nor requested the instant defendant to contact him, and also states the kite as illustrated herein was a communication sent from Benjamin Porter to him via an inmate at the county jail. 12. The instant defendant was arrested on May 25, 2017. 13. Counsel for the defendant, Mark C. DeSisto, ESQ, entered his appearance in this matter on May 26, 2017, participating in discovery under FLAR.CRIMP 3.220. Co-counsel Kevin Shirley, ESQ, entered his appearance on May 31, 217. 14. Criminal arraignment was initially set for June 6, 2017, and continued to July 17, 2017 and ultimately August 7, 2017. 15 Case management was held October 12, 2017 and the instant matter is set for pre-trial conference on December 19, 2017, with an early January 2018 trial contemplated. 16 Defendants Counsel discussed discovery with the ASA in this matter at the case management. The state was informed the defense is reviewing everything already sent to the state and will be updating them with additional discovery as received and reviewed. Counsel also informed the state, after review of the discovery in hand, it appeared there was only 2 pieces of evidence he did not receive with the discovery in this matter from the state. The ASA cordially agreed to get same to the defense, which should be received in the near future. Page 3 of 11. 17 There wasn't anything in the discovery, nor brought up in this discussion, to suggest anything else was outstanding in the discovery to be disclosed to defendant by the state. At the time of the discussion, defense counsel was unaware of this fingerprint report. During, and ongoing in his investigation, defendant's counsel was told by a credible, confidential source that a fingerprint analysis was completed on the kite dating back to June 2017 by the CCSO, well before receipt of the discovery in this matter. Defendant's counsel was informed this fingerprint analysis concluded there were no fingerprints on the kite belonging to Benjamin Porter. While still an assumption, the particularized facts as conveyed pertaining to this analysis suggests to defense counsel that this is a credible fact regarding the existence of this undisclosed crucial piece of evidence in this matter. Defendant's counsel assumes this fingerprint report was considered by the CCSO with regard to possible allegations/violations of law concerning Benjamin Porter. Being no charges to date have been filed regarding Benjamin Porter in connection with the kite, is only further evidence to support the assumption, if in fact this report exists, that the findings must be accurate as reported to defendant's counsel by his source. And, if in fact this fingerprint analysis report exists regarding the kite, certainly the CCSO must realize it is germane, directly impacts this matter and is certainly required to be disclosed to the ASA in this case for such disclosure to the defendant to take place in accord with rule and case law. The amount of time in passing since the ostensible report being completed and not disclosed in the instant matter is disturbing at minimum to defendant. This is an intertwined relevant piece of evidence with this cause and any investigation that may have taken place regarding Benjamin Porter. This kite is a material piece of evidence, it is evidence that more than likely will lead to additional evidence that is probative, and it is a piece of evidence that directly affects a piece of evidence that has already been presented in the discovery. In the instant matter, the kite discovery pages 157 to 158. Having this fingerprint report disclosed to the defendant becomes more critical, in that being the defendant's ongoing investigation, appears to demonstrate that Jamie Omar Sepulveda. Page 4 of 11. CI-15 to 57 has presented what defendant knows, and intends to submit at trial, false information, which is the basis for the instant arrest of the defendant. The CL's credibility will be a tantamount issue in obtaining a conviction of the defendant in this matter. For example, in part, Jamie Sepulveda, CI-15 to 57 has stated he never sent for, nor prompted the defendant to visit him. This is contradicted by the following, not including the defendant and additional defense witnesses already disclosed to the state. 1 interview of Lowell James Bailey on June 17, 2017, most notably. Yeah, it was definitely over a couple of weeks period of time where, he told me to tell, have Porter's lawyer get a hold of him so he could make a visit and talk to her. P3 of interview. Attached herein Exhibit B, 9 pages. 2 Interview of Joseph Herman on July 18, 2017, most notably. He's trying to find a way to get out of jail card, as always. So he tells. Shorty, Lowell James Bailey, you know what? Tell Ben Porter that, if he gives me $2,500, I'll go on the stand and recant my statement. You know? So. Shorty thinks he's everybody's middleman, so he goes back to Ben Porter and tells Ben Porter that. But at the same time, he's telling Ben Porter that Omar, CI 15-57, also told Shorty to tell him like, hey, man. Send your lawyer over here to make it official, so I can help you out even further. P1-2 of the interview. Attached herein Exhibit C, 12 pages. 3 Interview of Brian Harper on June 11, 2017, most notably. So he was outside the door from us. Him, Lowell James Bailey, and Omar, CI 15-57, talked back and forth and telling him to have homeboy S, that's Ben Porter's lawyer come see him, he would help out off the case because he was the CI in Ben's case. Page 3 of interview. Attached herein Exhibit D, 12 pages. Page 5 of 11. Credibility of witnesses. In considering and weighing the credibility of these statements by these inmate witnesses, the court should note that only one of these three witnesses was contacted directly by defendant's counsel. The one witness directly contacted was at the suggestion of his then attorney of record. Neither of these three witnesses were aware that each had made contact with defense counsel, nor did any of them know each provided statements during defense counsel's investigation. Nonetheless, despite these individual statements provided at different times and on dates separated over significant time, unknown to each of these witnesses, each of the statements corroborates the other. Background and contact with witnesses. Contact was originally made with witness Brian Harper earlier this year in case #16 558 CF, in which defense counsel was involved. During that trial, witness Harper had reached out through the jail detective to contact the state on his behalf. The message was misinterpreted. Being defense counsel was orally noticed by the ASA that witness Harper was reaching out for contact with him. Upon meeting witness Harper at his request, defendant's counsel made sure witness Harper understood he was not with the state and represented the defendant in case 16-558 CF. Witness Harper then requested counsel convey a message to the state, of which he agreed. Ironically, the message pertained to another CI in the jail connected to the then pending trial. Along with his CCSO handler, had been trying to recruit witness Harper into testifying in that trial and solicited him to commit perjury in the presentation of that testimony. The gist being, is witness Harper was asked to testify, as true, that he was a long-time friend with the defendant in case 16-558 CF on the outside, and the defendant had confessed his crime to him. This meeting ostensibly took place in the Charlotte County Jail months before the page 6 of 11. Defendant in that matter was arrested. The audio CD of the statement provided by witness Harper is filed in the court file in case 16-558 CF. Witness Harper explained he was reaching out to the state to ensure they knew their CI in that case would be lying under oath on the stand, and wanted to let them know so that the defendant could receive a fair trial. It was either during or right after this interview that witness Harper stated he had information relative to the instant matter. Counsel informed him he was counsel in this matter. but asked he relay whatever his information was post-trial of the then case being tried. Counsel informed him he would come down and see him to take a statement at conclusion of that trial. Which in fact counsel did. These are the only two contacts defense counsel had with witness. Harper Lowell James Bailey contacted the defendant's office and asked to meet being he had relevant information in this matter. Defendant's counsel met with witness Bailey once being apprised of this contact from him to defendant's office. This was the only contact defense counsel had with witness Bailey. Defendant's counsel received a message through a local attorney that witness Joseph Herman had information in this matter. Defendant's counsel visited with witness Herman after his case had been resolved. Although witness Herman was willing to speak off the record, he would not give a recorded statement for fear of retribution. Nonetheless, witness Herman asked counsel to recontact him in a week, allowing him to have a chance to consider going on record. Upon recontacting Mr. Herman, he provided the statement attached herein. This is the only contact defense counsel had with witness Herman. All three of these witnesses corroborated this was a setup by Jamie Omar Sepulveda. CI-15 to 57. That it was a setup he designed to avoid prosecution on a punishable by life case. All the witnesses independently corroborated that he was the person initiating contact with. Page 7 of 11. Benjamin Porter, requesting him to have his attorney make a jail visit so he could speak with her. These unsolicited statements given by three separate individuals, without knowledge of each. Giving them, and being warned and noticed on the record that as defense counsel, there was nothing they would receive for their cooperation in this matter, each of them provided corroborative evidence that was in total contravention to Jamie Omar Sepulveda, CI-15 to 57's statement to the CCSO. Additional credibility issues stumbled upon. Another issue that arose during investigation was the amount of time of contact between defendant and CI-15 to 57 at the jail. The probable cause affidavit states the visit was under 15 minutes. The audio statement of Jamie Omar Sepulveda, CI-15 to 57 states he met with the defendant for 6 to 7 minutes. Defense counsel has disclosed a defense witness, a local attorney in town, who intends to truthfully testify the defendant was in the jail visit meeting with the CI at most, a minute to a minute and 15 seconds. This is the same, and only jail meeting, that the defendant would have had with the CI. It is during this short first-time visit, that defendant allegedly sought the CI to commit perjury with promise of a bribe. Thus meaning, there would have to be introduction of the parties sizing each other up, the defendant covering the facts the CI laid out to the detectives and answering any questions the CI may have had, and making a bribe with instructions on how to, from who, and where to collect the bribe, all in 6 to 7 minutes if the CI is believed, or accomplished in a minute and 15 seconds at most, if the independent witness, a local attorney, is believed. Defendant has a FOIA request pending for all videos from the jail that we believe will corroborate defendant witnesses' information, although none have been forthcoming to date. Based upon the ever-mounting credibility issues regarding the CI in the instant matter that defense counsel is unearthing in his investigation, makes it ever more important to have the fingerprint analysis report of the kite that is intertwined, if not one of the basis, of the charge in page 8 of 11. This matter, disclosed promptly. CI, 15 to 57 claims this kite was received from Benjamin Porter. We contend, if Benjamin Porter wrote this kite, he would not have written it with expectation it would end up in the hands of law enforcement. The parents or Benjamin Porter, who have observed the handwriting of their son for 45 years have stated unequivocally that it is not their son's handwriting. Which appears credible based upon independent investigation of counsel as discussed, supra. Counsel has set deposition issuing a subpoena duces tecum, requiring writing exemplars be provided at deposition set in the near future. These exemplars are crucial in determining the credibility of the CI, or his total lack thereof, and which could have been obtained during the CCSO investigation, but ignored. Defendant contends this was a scheme/ruse that the CI played upon Benjamin Porter and the CCSO. In this ruse, the CI claimed the parents of Benjamin Porter were the parties that were to pay this ostensible bribe. This also alluded to in the alleged kite written by Benjamin Porter. Nonetheless, no corroboration of bribe on any written evidence to the parents, nor conversation on jailhouse phone calls has been presented. These were the only two ways of direct communication between Benjamin Porter and his parents. What is noteworthy to this fact, is during the interview of the father of the defendant. When finally allowed to observe the kite, he had to ask the detective what the 3 letters on the top of the kite meant. He was informed they are the initials of the CL, where it is learned the parents never even knew the CI's name. One would have to believe the parents were going to commit a crime, pay a bribe, to a person they did not know, in fact, did not even know his name. This is just another issue of no credibility, and a well-laid plan to fraudulently avoid prosecution and lengthy prison sentence. Closing. All discovery has been received from the state of Florida excepting 2 items discussed at the case management. Defendant has provided her discovery, nonetheless, it is ongoing. Page 9 of 11. Based on the discovery, the 2 most salient pieces of evidence that would support the allegation in this matter, is the testimony of Jamie Omar Sepulveda, CI, 15-57, and the undercover statement taken during the meeting between the defendant and the CI at the direction of the CCSO. While obvious to defendant, of which we will aver at trial, the recorded statement has been cherry-picked by law enforcement for placement in the media. A full reading of the statement will demonstrate the defendant did, nor said anything wrong. This including, anything that violated any law, or any ethical or professional rule. The statement, when taken in toto and not taken out of context in order to persuade only, illustrates nothing that would support a conviction in the instant matter. Based on the foregoing, this makes the credibility, or total lack thereof, of CI, 15-57. Jamie Omar Sepulveda, being of tantamount importance in this litigation. The test of his veracity will either be supported, or once again fall to ruin, when the evidence relevant to this matter, and that being sought, is disclosed to the defendant. Thus far, every issue investigated, and some not investigated, but arising, has been corroborated by multiple witnesses unknown to each other, and has been in total contravention to the allegation made by the CI. This kite, if in existence, which we believe it is, will be a piece of physical evidence that will either support the CI's claims, or show his allegations for what they are and remain, untruths in an ongoing scheme. This CI that had pure, unadulterated pure motive, to conjure up any facts he could to avoid a prison sentence. Quite frankly, as they all do. It is inherent in the program. If the party soliciting the evidence from a CI, has the power to reward that person, well, what idiot would not lie? If defendant's confidential source is accurate, which counsel has all confidence that she/he is, and the kite as alleged to have been written by Benjamin Porter, with disparaging information, concludes none of Mr. Porter's fingerprints are present on it, well then, it is just another indication that supports the defendant's belief that this is a fabrication of fantasy. Page 10 of 11. Designed for freedom by a desperate con, that has resulted in real-world harm to an innocent person. An arrest based on a fabricated ruse of a long-time utilized CI of the CCSO, which all evidence, testimonial and physical appear to contradict his allegation. Unfortunately, this is not certain. Wherefore, the defendant being entitled to full discovery and an opportunity to adequately defend herself against the false charge alleged, respectfully moves this honorable court to order the state of Florida to comply within 5 days. Certificate of Service. I hereby certify that a true copy of the foregoing has been sent by electronic transmission this point 26th day of E. 2017, to Office of the State Attorney, 350 E. Marion Ave, 2 floor, Punta Gorda, Florida, 33950. __ Mark C. DeSisto, Esquire. Florida Bar # 049-9862. 265 East Marion Avenue Suite 112. Punta Gorda, Florida, 33950. 941-479-6185 fax, 941-575-6400. Primary email, LEOAFFIRS@aol.com. Secondary email, mdes267@aol.com. Attorney for defendant. Co-counsel, Kevin Shirley, ESQ.
Need a car? Don't forget to stop by carmarshal.com, where you can scout through over 100,000 new and used car vehicles. Take a look around. Get you a new affordable car. carmarshal.com.
Hey Charlotte County, this is Charlotte County COPWATCH, and I found that I had to make a change this ending on my videos, letting you know about the channel and fair use laws, you know, how we can report on other people's reporting and how it's good, how it's bad, etc. But you guys can look it up yourself. It is legal. It's in there. But like I've told you before, that I've been cut off from making money on YouTube for 4 years. It's really weird, bizarre, but they cut the money off, but they said you can keep the channel, and now YouTube makes all the money. And if you get bored, plug it into Social Blade website, and you'll see that they are making a huge amount off the site. Right now it's at 63 million views, 53,000 subscribers, almost 3 million views a month. You know, trying to wake people up, and I make nothing. In fact, I got a customer that's ex-congressman. He said if I could ever find a lawyer, sue YouTube on it. But because this is nuts. 4 hours a day, and to save America. You know, but at the same time, it's worth it. Look at what our founding fathers did. They died for this country. So, but getting back to the money part, this is why I'm redoing the video. Is my dream of everyone giving $1, and it's going to be $53,000 a year, or if they did Patreon, which you know, can be monthly. That is not working. That'd be great if it did. Nothing is perfect. And I appreciate the people that do donate, you know, what they can on PayPal. And there again, I'm letting you guys know that is not much. Is, you know, monthly is, oh my god. So anyways, yes, you cannot live on it. It's very, very, very low amount. But the dollar things, I do appreciate that. But when I first said everybody give $1, that's not working. I'm just letting you guys know it's, yeah, that's that dream. Everybody gives $1. 53,000 subscribers, it's not working. So yes, if you can give more than that, you know, I appreciate it. Like I said, you know, I'm in a unique situation where, you know what, we're already debt free, and I'm not rich, but with the little business that we have, I am able to do what I am able to do 45 hours a day, you know, letting you guys know what's going on. In 4 years, I've did the whole thing myself. 12,000 videos on there. I literally get emails where people are like, holy crap, I never knew it was this bad. And it is this bad, and it's getting worse every day because we have the internet, we have cell phones, we have cameras everywhere now, and it's just disgusting what's going on. And then, as you guys know too, now we got Trump, we got Jeff Sessions doing a war on drugs, and now he wants to go after the forfeiture laws again. It's just unfreaking real. So, if you can give more than that, that dream of everybody giving $1, yeah, that old video, that's not working. They're not. They're just not. So, anyways, if you can give more than that, that dream is not working. Hardly anybody is giving. There you go. So that's why I'm remaking the video. If you can give more than that, that would be great. And there again, like I said, the Patreon's there. There is some people on there that are starting to give, but there again, it's very, very low. And like I said, I don't want to get rich off of that. I'm going to keep doing what I'm doing because, you know, it's still so stinking corrupt. It's not even funny. My court case that I'm going to be paying out of my pocket myself with Charlotte County's coming up. They illegally looked me up and then posted all my information on LEOAFFAIRS website. They basically doxed me, however you want to say that. I forget what the word is, and they outed me, man. And that information on that site went out to 500 sheriffs, deputies, people that work at the jail, etc., etc., etc. So, yeah, it is very, very scary, but we're going to do a federal case, 1983 case, violating freedom of speech. We have 17 cameras in the house now. We got 2 cameras in the car. I always carry a camera plus a cell phone. A lot of people are highly recommending I get a vest now. If I could, if the wife would let me, I would run for sheriff. We are trying to push the thing nationwide right now. Where just to mix it up and to get the topics out there is register to run for sheriff, NPA, no party affiliation, as a write-in, and that is completely free, and you can participate in the elections. And there's a lot of stuff. We got a guy, James McLinnis in Pinellas County, Tampa, who almost won. He experienced the corruption himself. The story is unbelievable. Look him up. It's mind-blowing what they did. It pissed him off. He is very, very smart. He has way more money than I did. He ran for sheriff at the last 3 months last year in 2016 and almost won. He got all of the black vote. And the reason why he did that is because he ran in, I will not bust, we're in Florida, I will not bust anybody for weed anymore unless it's an ungodly huge amount, like pounds. And then he also ran in no more victimless crimes, no more of this freaking road pirate bull crap. And then he was going to cut the budget by 30%. And when you think about that, you can. If you stop the road pirates, you can get rid of a bunch of people. Gone. So, the wife has been saying, yes, I can, yes, I can't. So I don't know. We're trying to find somebody that can do it because I am busy doing this anyways. But, so I'm making a video, like I said, that $1 a month from everybody, you know, for 53,000 subscribers, that is not working. I'm just letting you guys know. Absolutely give way more than $1 a month. If you can, I appreciate anything. By the way, remember too, when you give that, PayPal takes like freaking 15 to 20%, so it's even worse than that. But, and there again, like I'm letting you guys know, it's way, what I get is very, very low. Appreciate it. But it is very, very low. Can't live on it. I'm just, you know, I'm working, and that's what I'm working on. And that court case is going to cost a buttload of money. That's federal court. Just the filing fees and the depositions that we're going to be doing with this corrupt cop. So there's another reason to give. We are going to be doing a deposition with this very corrupt. He was in a drug squad. He is a bad guy. He's on steroids. We heard steroids are rampant here. That's why their attitude is so bad. And we are going to get him on video, and it will be on YouTube. So that case alone is $5,000 just to bring it to court, and that's my money out of my pocket. So there's another reason to give, and give way more than $1 if you can. So keep that in mind. This is the new video, and I see, God, I talk a lot. It's already 7 minutes, but had to make it just to let you know that $1 a month from everybody is not working. They're not doing it. So if you can give more than that, please. So thanks. Keep it up. Share, like, subscribe, tell your friends, send me your videos on corruption, and I'll post it.